So welcome everybody to our Probate 101, Avoiding Pitfalls and Expense of Probate. Let me introduce Phil Summers. A lot of you may know Phil already. He is one of the co-founding partners here at Generations Law Group. He is also the probate team leader. And he's an all-around pretty decent guy, I gotta say. So Phil, I'm gonna hand it over to you.
Thanks, Carol. Good afternoon, everyone. Welcome to our presentation on probate, the pitfalls and expense of probate. So having been dealing with the probate courts for quite a few years, there's a good reason why we want to avoid probate. It can be very challenging to those going through it, and particularly for families who are needing their, their loved ones' assets to live on. So probate can test your nerves to the rest of everyone. So when you talk about probate, it really begins with before you die, in terms of how you set up your estate plan, in terms of if you have a will, trust. It really determines how you will intersect with the probate court, or maybe you won't have to intersect with the probate court. But it begins with the estate planning. And when we talk about probate, it really starts with the assets. You're changing the title from one person to the next. So assets that have to go through probate are titled in the decedent's name. Probate, you remember, is a very public process. So anyone can go into the probate court, also online, and actually see the decedent's or the testator's last will, what assets are in the estate, who's getting what. So these are all the things that you can go to the probate court. Why do I bring that up? Particularly for children who maybe have credit problems. I have had cases where before the distribution was made to the beneficiary, maybe a son or daughter, creditor swoops in and claims the inheritance. Children who've gone through divorces, they've also been subject to the family court. So remember, probate is a very public process. Probate, there's one misconception I just want to clear up right now. People think, well, if I have a will, I don't have to probate. That's absolutely not true. When you have a will, you have to probate. It goes through the probate. It's really the court that allows the acceptance of the will. They kind of give their stamp of approval. This is a valid will. One of the downside is wills are subject to challenge. They can be contested in the court. They can be really delayed if someone really wants to make the process very difficult. And also very time consuming and expensive. Is not an inexpensive process to go through. When I say time consuming, by statute in Massachusetts, we have to keep the estate open for 1 full year. And that's to allow creditors to make claims against the estate. You may be able to make partial distributions, but the estate has to be open for that full year. After 1 year, creditor claims are barred. Interesting, Massachusetts is one of the longest durations to have estate open in the country. 1 year is the longest in the whole state. So when you're talking about an estate, you find out if the decedent's will is valid. So you want the court to say, all right, this is valid in the way the testator created. It was witnessed by 2 witnesses, notarized. Those are certain formalities that have to go through. But there's also a number of points where a will could be contested. But the will is accepted into the court. Why is that important? Because that's kind of a roadmap as to how assets will be distributed if the court allows the will. Now, if there's no will, you've passed away in what's called by intestate. And now the laws of the Commonwealth of Massachusetts will dictate who gets what. Again, remember, the probate is really changing the title or ownership, particularly of real estate and personal property. You want to make sure the court validates the will, because then the heirs, particularly in real estate, you want to make sure you have good title. And the title examiners will look through that no one didn't sign off on a property sale who was entitled to receive ownership of the property. One of the other aspects of a probate is you need to pay all the decedent's creditors, all the legitimate debts of the estate. And we'll talk a little bit about that more a little later on. Another purpose of for a probate is to get medical records. I've had several cases where the sole purpose of the probate was to appoint a personal representative. It used to be called an executor, by the way, or executrix, but appoint a personal representative for the sole purpose of filing a malpractice or personal injury claim, to be able to sign the suit, and to be able to get those records and commence it against whoever the defendant would be. And then finally, to file tax returns, be able to sign the return, to be able to, if there's a refund coming back, you need to have authority. So when you go to the probate court, you're asking the court to name someone to manage the affairs of the state. And that person basically steps into the shoes of the decedent to take action, managing assets, paying legitimate bills, paying taxes, things of that nature. Now, there's times when probate is not necessary. And it really starts with the question is, what is a probatable estate? I think that's the more salient question. What's a probatable estate? Probatable estate are assets that are solely in the decedent's name. If assets are jointly held, like real estate, if you own it jointly with your spouse, by tenants by entirety, by operation of law, when you pass, it goes to the joint title holder by rights of survivorship. Now, you have a probate estate and you have a non-probate estate. So that'd be an example of a non-probate estate. Jointly held accounts, again, by operational law, goes to the joint account holder. It's not part of your probatable estate. Another type of estate, when you're looking at types of estate, is your estate for estate tax calculation. So actually that would include everything. It would include everything that goes through probate, because we're trying to transfer title from one person to see non-probated assets like joint accounts, real estate. And also property that's held in trust is still counted in your taxable estate. So remember, it's probatable estate, non-probatable estate, all is used to determine your state tax liability. Just as a reminder, in Massachusetts, we're a threshold state. So anything over $1 million, the whole estate is taxed. Typically, we find most people in 7 to 8%, but it does vary from 5 to 16% of the estate for Massachusetts estate taxes. All right, let's talk about the probate process a little bit. So really, again, as I mentioned earlier, it starts with your estate planning documents. If you've done it correctly, you can avoid probate. If everything's in trust, I'll talk about trust and ways to avoid probate later on. But the process really kind of kicks off with filing a petition to commence the probate. And in the petition, you're asking for several things. First of all, you want the admittance of the will. You want the court to allow the will and to appoint a personal representative of the estate. Again, the personal representative used to be called executive or executrix. What does the personal representative do? Well, first of all, they're supposed to gather the assets of the estate and manage those assets. And remember, PR has a fiduciary responsibility to all stakeholders of the estate. That means heirs, beneficiaries, devisees. Devisees are the people that are named in the will, creditors as well. They also have standing in an estate. As a matter of fact, if no one actually files a probate petition, a creditor can file a petition to open up a probate estate for the purpose of them getting paid, and that has happened before. Who gets notified? Well, it's we remember in probates, you probably see in the newspapers those legal notices, so the world gets notified of someone passing and the petition to appoint a personal representative, but also the heirs and devisees, again, the people named in the will. How long does it take? Well, that depends. I'll use a lawyerly response. It really depends on each case. So typically, again, we mentioned we have to get the probate open for a full year, but certainly probates can take much longer than that. if families do not get along, if we have siblings or beneficiaries that decide to be litigious, object, that really can delay the process. I had one probate case, actually fairly recently. The mother left her house to her daughter. Her daughter was her caregiver, took her to grocery shopping, actually lived with her, provided all the care necessary in her later years. And she really forego her own career to help her mother out. In her will, the mother wanted her daughter to have it. That seems like a reasonable thing to do. And remember, testators have you can decide who you want to get your things, and she wanted her daughter to have it. As soon as the mother died, the brother filed suit. He had no legitimate claims. He was written out of the will, but he kept objecting, delaying the process, and unfortunately running up the costs of our client. But there's really nothing to do, because when you object, the court's not going to allow certainly the final closing of the estate or any distributions until those objections are resolved or quashed in the probate court. I've had other clients where a person filed suit or objected to the probate because she was not given the toaster that her mother had promised her as a young child. I mean, it's kind of silly things like that, but they do happen. And unfortunately, it really delays the process. So let's talk a little about wills. Everyone should have a will, because even if you have a trust, and we'll talk about trust-based plans, you want to have a will to kind of catch everything else up in your estate that maybe you didn't retitle into the trust or funded the trust with it. But there are some certain things about wills you should know. It only becomes effective upon your death. It's not something that is used during your lifetime. For example, if you have incapacity, those are certainly issues or downsides to having a will. Again, in wills, we talked about, it's a public process. Anyone can see who gets what, who gets, in the process. And they're certainly subject to contests or arguments that can really delay the process. So again, we talked about some of the risk. One thing I didn't mention, if you cross state lines, sometimes you have difficulty. You may have to do an ancillary probate in another state. For example, if you own a house in New Hampshire or down in Florida, to get good title or pass that property, you have to do the primary probate in Massachusetts, but also perhaps have to open up an ancillary probate in the other state if there's property located in the other state. You should also know wills do not control most of the property of an estate. Obviously, there's stuff that's controlled by the will that passes through probate, but many things do not provide control the property. And also, look at it this way: a will really controls the estate for a very short time when you pass, but doesn't allow for ongoing maintenance or ongoing oversight of the legacy you leave to your family. So a will basically is a roadmap: what is there and who gets what, and that's what we're looking for a will. It has a very important purpose, but a very limited purpose. So many people think, if I have a will, that avoids probate. Far from it. When you have a will, you have to probate the estate. So some of the things we suggest to clients if you want to avoid probate. Simple thing is, make sure you name beneficiaries on your accounts, like your retirement accounts. You can also have transfer on death on some of your bank accounts. When there's no beneficiary named or joint ownership on an account, then it has to go to probate, because no one knows, like the company that holds the asset, they don't know who it should go to. They're not going to look into the will. They're going to wait for authority from the court to direct them as to who gets the property. Also, putting your assets in trust. And we're going to talk about trust a little bit later on. There's many types of trust, but trust certainly has a very desirable effect. And also, for the most part, it'll avoid probate. So let's talk a little bit about trust. Trusts are a private document. It allows you to talk about how the assets are managed during your lifetime, if you have a revocable trust, and after death. And you, as the person, the trust maker, have full control over the assets. Again, it's a revocable trust. You're the trustee, you're the beneficiary. Trust documents allows you to choose your successor trustee when you pass. Maybe it's your spouse, children, who knows, but they'll have to manage the trust assets per the terms of the trust. Now, remember that, once you pass, the trust beneficiaries have immediate access to the assets. Or you can certainly have stages where you say, well, maybe a child's a minor. Maybe you want to release certain portions over time, maybe at age 20, 25, 30. Depends how mature your children are. I remember the trust we had set up for our children. We kept pushing the date out. I think we're up to age 35 now. So hopefully they'll get the money at that time. Also, remember, trusts are private agreements and they're typically not subject to creditor claims. Probate, very public process. Creditors that come swoop in, they know exactly what's in the estate and who's getting what, and claims can be filed against the estate. Trust, typically very private. Creditors don't have access to it. They don't know who's getting what. And then another thing that's certainly a benefit of trust, it provides for tax planning in the possible savings of estate taxes. I won't get into too much detail, but you can certainly catch up, particularly if you have a married couple, you can catch up half the estate under the first person to die, and then certainly minimize your estate taxes. So a trust, can be ongoing over your lifetime. Again, you're talking about the children, you're having the stages. Typically, we write language in a trust to have the trustee make disbursements to, certainly your children, or at different, stages, or for different purposes, health, education, tuition payments, maintenance. That's typically like rent and things of that, in support. So really, we give the trustee oftentimes the discretion to release those funds in those different types of stages. The nice thing about trust, you can control the distributions over a lifetime. Remember, I talked about earlier, wills are only in effect really a short period of time, very short term. Get it to the probate court, direct the probate court how things are going to be distributed. Whereas a trust can really have a lifetime beneficiary control, so to speak, in terms of how you want the money managed and for what purposes. And if you don't have a will, remember, the intestate laws of Massachusetts take effect. So now you don't control who's getting what and when. It's really subject to the intestate laws of Massachusetts. One thing to remember, it's not true that people have this mistaken belief that, well, I don't need a will because my spouse will get everything. That's not always the case. I had a case a little while ago, second marriage. The husband, who was decedent, had children of a prior marriage, and then remarried and then passed away. The second spouse did not get everything. There is a portion, according to the intestate laws, where the first children did receive a portion of the inheritance. So don't make that assumption. Also, we had a horrific case years ago where young family, it's really kind of a sad case. The husband passed away. They had no children. It was just a surviving spouse. It was actually a second marriage. The husband's father, who had abandoned him as a child, received a portion of the estate. Again, these are one of the unintended consequences of an intestate distribution. He was a rightful heir to the estate. Didn't matter what his relationship was with his son who passed away or the family. He was entitled to a share of the estate. So just keep that in mind. Depending on the situation, it's not true that the surviving spouse gets everything.
Well, before I go on to the next slide, Phil, we do have a question.
Okay, sure, great.
What is the difference between beneficiary and transfer on death for a bank account?
Sure. Beneficiaries are typically in your 401ks. So when you open up your 401k, you have a name beneficiary. They're very similar. Transfer on death is used in the banking world. transfer on death when someone passes away. So the end result is basically the same.
Okay.
All right, let's talk a little bit about revocable trust. Well, first of all, there are a million different types of trust. There's like, it seems like a flavor of the day, trust. But there's really two broad categories. There's the revocable trust and there's the irrevocable trust. I'll talk about the irrevocable trust in a moment. First of all, the revocable trust. The nice advantage of it allows you to keep control, a key phrase, allows you to keep control over your lifetime. You are the trustee, you are the beneficiary, and also the typical purpose of a revocable trust is to avoid a probate. And also previously I mentioned you can use it as a tool to minimize your estate taxes. Remember, it's still, even though it's in a trust name, it runs under your Social Security, you still have control. Like it has that benefit of avoiding probate and also all the negative things of probate, the time and expense of going through it. Revocable trust, your beneficiaries would have immediate access to the assets if that's what your intent is. Let's talk a little bit about irrevocable trust. So big difference between revocable and irrevocable trust. I view it as you're putting an asset in a steel box, all right? Now that steel box, it protects it against creditors in the outside world from going after it, particularly like for a mass health planning. But that steel box also protects it from you. You lose control over it. You have a trustee that's managing it, not you. I know it's if you're losing control of that asset, sometimes it's a bridge too far for people to go. But again, you get that protection, that asset protection quality of it. You take that asset basically out of your estate from your taxable estate. So you have estate tax benefits, has the same benefits of probate, but it's really for an asset protection. If you have an asset, you don't need that value of the asset. It's a way to protect it from nursing home care. I would strongly suggest you speak to an estate planning attorney to make sure it meets your planning goals, because it's not for everybody. It has certain benefits, but there's also some downsides you need to make sure you're aware of. And the last slide we have is just a plug that we have for an ebook, but we wrote an ebook. It's a free ebook if you'd like to take a look at it. What to do after death in the family. So we get calls. It's remarkable how quickly we get calls when people pass away from the family, within days, which we always, we'll always take the call and certainly speak to the family. My first words of advice when I get those calls is grieve. Make sure you get through the grieving period. Take care of yourself. The probate doesn't have to be done immediately. We can certainly do it at the proper time. But we wrote this ebook with the thought of, all right, what should you do in the immediate, the first 2 to 3 weeks, the first month, the first 6 months? They kind of give you a checklist. Some of it is kind of the legal stuff you need to do, but most of the stuff is talking about things you need to think about, canceling this or canceling that, kind of the responsibilities you need to have going through the, if you need to probate, but just really kind of help the family through kind of that initial thing. So hopefully, if you'd like to get a copy of it, you can talk to Carol, and I think she's put it up in the chat box. So with that, and what I want to talk to, I'll be happy to take anyone else's questions.
No other questions though, Phil.
No, I think that's it. Well, thank you very much. And hopefully you won't need my services, but if you do, we're certainly here. Then also, so if you want to do planning, we're here as well. But thank you for attending, and we look forward to you joining us for some future programs that we have scheduled.
I think that's about it for today. Thanks everybody for joining us and taking time out of your day. Hope it was helpful, and thank you, Phil.
All right, thank you, and have a good day, everyone.